with Jordan, and I really like to start with the basics when we talk about estate planning. I have been to so many of these educational presentations, and I still feel like I only know the tip of the iceberg, and I still get, very confused, especially on the subjects that we're going to be concentrating on today. So let's start with what are some of the most common myths and misconceptions regarding estate planning?
Sure, great question. The number one myth is probably that I hear from people is that I don't need an estate plan. I'm not a multimillionaire. I'm not Jeff Bezos. I don't have this massive estate that requires an estate plan. And so when we look at that first myth, we want to kind of look at the why behind the myth. And you had touched on it previously. Okay, who here likes to talk to lawyers? Who likes talking about death and incapacitation? Yeah. So, realistically, we know that. We know that nobody wants to come talk to a lawyer about death and incapacitation. So, especially at our firm, we try and be the least lawyery lawyers that you know. I'm wearing jeans right now, and I'm wearing basically some sneakers. If I'm up here in a black suit and I already look like I'm at your funeral, nobody's going to welcome me out. So we have this truth that nobody wants to talk about it, but 100% of people are going to be affected by it. So we have this catch-22, this two sides of a coin that we have to overcome. So we look at that myth and we go, okay, I don't need an estate plan because I'm not a multimillionaire. I don't have millions of dollars of assets that I need to distribute. I don't have a troubled family. Everybody gets along. It'll work out fine. That's not true. The second myth that I hear is, I have a will, so when I die, I get to avoid probate. So who thinks if you have a will, you avoid probate? That's not true. If you have a will, you will go to probate. I want you to kind of make that connection there. Your will is your ticket to probate court after you pass away. Because the only place that a will has power is in a probate administration. You have to present the will to Judge Murkowski or Judge Rose here in Kent County for the will to have any power. So we try and explain, and no, if you have a will is great, we need it, it's a tool, we're going to talk about what it does in a little bit, but a will take you to probate court. And then the final myth that I probably hear the most often is, estate planning is really just the who gets my stuff when I die language. It's just the who gets my stuff after I'm gone. And estate planning really affects anybody who's 18 years and older and still fogging a mirror, all the way up to and including and past death. It's not simply who gets my stuff when I die. So kind of explaining what these different tools do, when they are applicable, and then how we use them, that's my job. And if I can't educate somebody who has no understanding of these estate planning documents, then I failed as the professional. So if you're not sure what a power of attorney does versus a trust versus a will versus all of these other tools that we use, that's totally fine. You shouldn't know those things. That's why there's professionals. I don't know a whole lot about a whole lot. I know a whole lot about this very little practice of the law, and that's where my job as the educator to provide the education to you on these tools and when to use them.
And that brings us right into my next question, which is, we tend to live in a very DIY culture, and it's not uncommon to get that feeling that we can tackle almost anything with a few Google searches topped off with a YouTube video. You should have seen me take down a wall with a Sawzall the other week. I think my husband would have had a heart attack if he was watching. So I'm super notorious for trying to save money by doing things myself, and yet I have also learned that the complications and challenges that arise from sometimes doing things that I truly don't know how to do end up coming back to bite me. So what would you say to somebody who has that, I can just download a version on the web and fill it in?
Yeah, one of my favorite, at a previous law firm, one of my favorite things that we bought for one of our associate attorneys was a coffee mug, and on it said, "Please don't confuse your Google search with my law degree." Because you can go out and look for anything online and you can find it. And whether it's true or not, or whether it's accurate, is debatable. My favorite story is I had a family come in and they said, oh, we have an estate plan done, we just want you to look at it. I said, okay, great, I'm happy to review it and let me know what it says. And they had found it on, I'm making up the website, legaldocuments.com or estateplanninggdocuments.com or something. And on the bottom of every page, they had it printed, this is not a legal document, please consult with an attorney before executing. Like literally, they're out there, providing these documents, but they're at the same time going, but we don't actually know what we're talking about, so go speak with an attorney. So we, when we're looking at the do-it-yourselves, the find online, we want to again look at the why. Why do people do that? And the first reason is probably expense. We talked about nobody wants to talk to me in the first place. I get that, but nobody wants to spend money, thousands of dollars on a estate planning document. So when we look at the expense, we always want to make it relative to something. And my friend Alistair Lynch is over there. Make sure you stop by his table. Make sure you go say hello. And Alistair can correct me if I'm wrong, but I always like to look up what is the average premium that we as Michiganders pay for the state of Michigan for our auto insurance. And I always like to use this example. So the latest number that I could find was $3,817 per year per family in Michigan for auto insurance. Now they actually broke it down into seniors, which I actually thought was very applicable here, was $2,977 per year per family. Now of course some people have more cars and but this is just the average. So in Michigan we pay thousands of dollars a year to insure an asset that is depreciating each and every year, and we pay for it each and every year, and we probably pay more this year than we did last year, and we're probably going to pay more next year than we did the previous year. Now, why do we do that? Well, one, it's a good idea. Everybody should have proper insurance on their automobiles in their home, of course. But the law also requires it. So, now, am I promoting that the law requires everybody to get an estate plan? No, I'm not. But we pay it because we see the value in it. If we're in a car wreck, we know that our insurance hopefully is there to back us up. The problem with estate planning is so often the thing that causes us to recognize the value of it happens before we have it done. And then our options are so much limited compared to if we actually plan ahead of time. So yes, nobody likes spending thousands of dollars with an attorney for estate planning. But if you could insure the entirety of your estate for the cost of car insurance for a year and avoid a lot of the problems that we're going to talk about in the future, I strongly recommend you do it. Because if you don't, and we don't have those documents in place, our options are just so limited or so much smaller than if we actually have documents in place. So cost is obviously the big one that drives people to do it yourself. The second is just, I don't understand the consequences of what I'm doing. And I found a document that said will or it said power of attorney on the top. And so that looks like what I should be filling out, so I'm gonna fill that out. But the unintended consequences of improperly done or poorly done estate planning can be catastrophic. It can be, like we mentioned before, the wrong person getting something from your estate, or the wrong person having legal access or authority to make decisions for you in the event you can't make them for yourself. Or it just simply doesn't work because it doesn't satisfy the statute that's behind it. Now, how many people knew that we recently, the governor recently signed the Uniform Power of Attorney Act in place that's going to change the way powers of attorney act in Michigan starting July 1st, 2024. If any of you raise your hand, I'll be shocked, because you shouldn't know those things. Again, that's not your job. Your job is to go live your life. But if you don't know that, and you execute a power of attorney that isn't in compliance with that, when you actually need to use it, it might not work. So cost, I know, is an issue. The desire to do it yourself and go, hey, I found this online, without understanding the full consequences are some of the things that we want to try and overcome so to make sure that you've got the right plan in place that actually does the thing that you want it to do.
Well, one thing to add on the cost too, we quite often end up working with people on the back end who, families who had a relative who did not have an estate plan in place. And there's a fairly significant cost after death when that happens too. So as I talk to people about that, I encourage people to look at the cost you're spending now, is really an investment. It's probably an investment you're doing for the benefit of your beneficiaries, maybe your kids, your grandkids, and I think it is. There is, I think that's a big barrier to estate planning, but I think if you look at the big picture, it will save your beneficiaries not only maybe some heartache, but some cost down the road too.
Yes, I firmly believe it's that idea of you're either paying it now or you're paying it later, and it is so much easier to do the ounce of prevention versus the pound of cure in this case. So Jordan, can you walk us through some of the basic legal tools that are used in estate planning, and what is the primary use of each one of those?
Yeah, fantastic. So whenever I meet with a family, and by the way, we do free consults for anybody, so you can come in and we can talk about this stuff. And you don't have to worry about spending a lot of money to get the education. But we always start with the 4 cornerstones of a good plan. And the 4 cornerstones start with a medical power of attorney with a HIPAA authorization. And this is a document that basically says, if I can't make my own medical and care decisions, I've empowered this other person, like my good friend Chad, to make those medical and care decisions for me. Now, a lot of people think, oh, I'm married, so it's fine. My spouse will have unlimited access to my information and unlimited decision-making authority, and it's just not true. And we don't know, maybe your spouse has become incapacitated, or maybe a spouse is predeceased. So we want to make sure that the right people can call the hospital and say, hey, is Jordan there? And they can, yep, we can release this information using room 5412, and these are the things that are happening. So the first thing that we always start with is a medical power of attorney with a HIPAA authorization. The second cornerstone, the second tool, is a financial power of attorney, and it's very similar, but instead of medical and care decisions, it's simply financial in nature. So it's somebody who can pay my bills, can fight with the IRS, can apply for a government benefit, can do things that are more financial in nature. And again, they can be the same people that you have under your medical, or they can be different. Because you might say, my daughter is an ER doctor. Wonderful person to have as a patient advocate. Would love for them to make medical and care decisions. But she doesn't know how to balance a checkbook. So maybe we don't want her making the financial decisions. And of course, I'm just picking on this hypothetical person. So we want to make sure that, again, the right people have those decision-making authorities under the powers of attorney. Once the powers of attorney are in place, we've really taken care of all of the decision-making that you might have to have made for you while you are alive, but unable to do it. The powers of attorney die along with you. The powers of attorney die along with you. So once somebody passes away, we can't take that power of attorney down to the bank and say, Jim Vanderdijkensma died. I'm his agent under his power of attorney, so I want to close his bank account. They can't do that anymore because the powers under that POA are null and void at death. So that's where we look at the third tool, something called a will, a last will and testament. And the last will and testament is just like it sounds. It's your way of telling your will, your desires, and testifying to it. And in that will, we're going to do a couple of things. We're going to first name the personal representative of your estate. And the personal rep of the estate used to be called the executor of the estate, the executor of the estate. But I think people started thinking of guys with like hoods and an axe or something. And so personal representative sounds much more administrative in nature. And the personal representative only has authority over your estate after you pass away. So what do? Well, they deal first with the funeral home. So is there going to be a burial or cremation? Something to do with your remains. They're going to work with a CPA, hopefully, and file your final tax return. Because your Social Security number, the IRS is looking at that Social Security number basically every year and going, did that file a return? Did that file a return? Did that file a return? And in the year you pass, we want to file your final 1040 return, basically letting the IRS know this Social Security number is now retired. Don't look for any more tax returns for it. Did I mention you should be doing that with a CPA? Please don't go and try to do it yourself. The third thing that the will is going to do with a personal representative is name guardians for minor children. So if you have any children that are under 18 years old, or if they're developmentally disabled, or if they have something that requires them to have a guardian, we name guardians for them within the will. And then the last thing that the will does is it's the who gets my stuff when I die language. So anything that isn't jointly owned with somebody else, doesn't have a beneficiary designated on it, or isn't held in trust, goes through a process called probate administration, in which we present that will to the probate court and say, okay, John Smith passed away. This is what John Smith wanted to have happen to all of his stuff. He would have said that, but he's dead, but he wrote it all down first, so the judge will make it so. Now, there's nothing wrong with that. It just takes, 12 to 14 months, and a typical probate in the United States costs about 4 to 6% of the entirety of the estate that's running through probate. So like Chad and Laura mentioned before, yes, estate planning costs some money on the front end, but it often saves multiple times that on the back end as we avoid probate administration. The last tool we use, kind of the fourth cornerstone, is something called a trust. And all a trust is merely a contract. It's merely a series of rules, a set of rules that says, if I put something into this trust, this is how I want that thing handled if I'm incapacitated and ultimately after I pass away. One of the big, there's lots of big factors that I would use a trust, but one is anything that's held in a trust avoids probate administration after you pass. So it's a huge savings on administration. The second thing is you can manage the asset for the beneficiary. For example, I have 2 kids. William is 15 and Ryan is 14. If we gave them, if my wife and I got hit by a meteor, we gave them our estate right now. One, they can't legally own it because they're not 18 years old. And for the guys in here, if you were an 18-year-old male and you got handed your entirety of your estate on your 18th birthday, the females are much better off than we are. But our brains don't develop until finish developing until we're 25. So
Fast car. A fast car.
I joke it would be a super fun week, and then I would probably have some regrets. So if we have that trust, we can manage those assets for our beneficiaries without giving them too much too soon, while still taking care of them. There's a lot of different kinds of trusts, but people overcomplicate the idea of a trust. It's not just for multi-millionaires looking to save taxes and using some account in the Caymans. It's really just a way to manage assets for the benefit of your family. Those are the 4 biggies. There's a million other tools we use, conservatorships and guardianships, things that if you don't have powers of attorney in place are basically court-governed proceedings to appoint somebody to make decisions for you. They're great things when we need them, but we try to avoid them at all costs because anytime you're in the courts, it takes more time and it takes more money. So we look for ways to avoid those. But power of attorney medical, power of attorney financial, a will and a trust, those are kind of the 4 foundations of a good plan.
So Jordan's an overachiever and just answered the next 3 questions that I have. So thanks, Jordan, for that.
I can go into just detail on all of them.
So he established that power of attorney, dies with the person. So that's something that I really just learned in the last few years and pretty important. One thing that I like to mention that I was introduced to just a few years ago, we always think of these legal tools in relation to our older parents, our grandparents, and so forth. But I'm going to call her out. My wonderful daughter is sitting in the back of the room, and just after she hit her 18th birthday, I had Jordan draw up power of attorney papers that were both legal and financial, and all of the health power of attorney forms, because honestly, as a mom, and my youngest just turned 18, and we haven't gotten the documents done for him yet, if something were to happen to him tomorrow, the hospital will not talk to us as a parent unless we have those forms in place, which seems crazy to me because I'm like, but I'm the mom. I've done it all. I should have all of this. But legally, once your children are adults, 18, as same thing, I don't consider my 18-year-old an adult, and yet in the eyes of the court and in the eyes of the medical industry, they cannot legally give me information unless he has okayed it. So that's just kind of something I always like to mention. And then,
can I jump
absolutely.
in? So we do young adult college age planning regularly, and in addition to the example I always use is the son or daughter, the 18-year-old goes off to college for the first time, and for some reason I always pick on Central Michigan, and they're at Central Michigan and they get in a car accident and they go to the hospital. As long as they're an adult, like you mentioned, the parent can call, but they cannot release the information.
And in the eyes of the law, they're going to say, well, this person's an adult, and we don't want to make presumptions on behalf of this person. Because maybe they have a terrible relationship with their parents, or maybe there's a reason they moved out of that house and don't want their parents to know this information anymore. From an educational standpoint, colleges and universities won't release educational records either. I see some head nods there. And when I explain this to some clients sometimes, you can almost see like the vein get real big and the neck gets red. They're like,
I just paid that tuition bill.
I'm paying how much in tuition, and you won't tell me if they're going to class or get. And so we can actually, in addition to a HIPAA authorization to release medical records, a financial power of attorney to make financial decisions, and a medical power of attorney to make medical decisions, we can do it something called a FERPA, which allows the university, the college or university, to release educational records to the parents. Now, we can't force these, as you well know, we can't force the 18-year-old, 19-year-old, 23-year-old, whatever, to come in and do them. They have to do them at their own volition. But it's something we strongly recommend in that college-age young professional demographic, to make sure that if you are the parents, they're still on your insurance, you're still paying, the tuition or whatever, that we get those in place, and that way you have access should the worst happen.
Yeah, I just love the idea of trying to be proactive. There's so many things that life throws at us that we can't be proactive for, that those areas that we can, it just makes sense in my mind. So we talked about how those powers of attorney change. Now, if someone is actually not dies, but is incapacitated, who actually makes that determination of incapacity, and are there tools that take over in that case? How does that work?
Yeah, great question. Often we have clients that they want to know how incapacity is determined, because they don't want one of their kids making a run on them saying, oh yeah, mom and dad's now lost their mind, I'm taking over, right? And I try to assure them that incapacity is a legal and medical standard that needs to be met. And it's two licensed physicians that have personally examined you have to go through this gauntlet of tests. People with a whole bunch of letters behind their name have to send you through these tests to determine if, one, you understand the breadth of your estate. Do you generally understand what you own? Do you think you're Jeff Bezos and worth $250 billion? Or, no, I have a house, I have my 401k, I generally understand what I own. Now, it doesn't mean you need to know the exact balances at all times. That's not what we're talking about. But do you generally understand the breadth of your estate? The second factor is, do you understand the legal consequences of your decision? Now, again, that doesn't mean are you an attorney that understands the statute that it was written on, but do you generally understand if I sign this document, I'm giving authority to somebody, or I'm transferring assets to somebody else? And then the last factor they look at is, are you generally acting in your own best interest? And where this comes up is, I had a client a number of years ago. The Girl Scouts come door to door and they're selling cookies, and he was a fan of not only the cookies, but I'm sure that the neighborhood girl down the street who he watched grow up, and he wanted to buy like $25,000 worth of Girl Scout cookies. And this wasn't a multi-millionaire who could burn $25,000. This was somebody who needed to guard their assets. Even though he thought it was a nice thing to do, to say, hey, I'm going to make you the top-selling Girl Scout cookie seller, in America, that was not acting in his own best interest, because losing that amount of money would have been very detrimental to his lifestyle. So neurologists, psychiatrists, psychologists, and medical doctors will send the proposed or the person through a series of tests to determine whether they are incapacitated. And if they are incapacitated and they have a power of attorney that triggered upon incapacity, the agent that they named under the power of attorney would have those powers, those authorities that were given to them. Now, if they don't have a power of attorney, we go through this process called conservatorship and guardianship. And it's a court-initiated, court-governed process in which the court will appoint somebody. The guardian is that person who will make medical and care decisions for the person that's incapacitated, and the conservator will make financial decisions for them. Now, the reason I try to avoid these at all costs is they take a long time and they can be expensive. And if you really want to ruin Thanksgiving, have a family go through a guardianship conservatorship process. In a guardianship or conservatorship process, the processes are very similar. A petitioner basically says to the court, hey, John Smith can no longer act in his own behalf. I want to make his medical decisions. I want to make his financial decisions. I'm the petitioner. I'm asking the court to give me those authorities. The court then appoints a guardian ad litem, GAL. And the GAL's sole responsibility is to defend the rights of the proposed award. So the guardian ad litem will come out and meet the person, and they'll interview them, they'll see how they're living, they'll basically run them through a series of tests to go, okay, does this person have the authority to, the capacity to make their own decisions or not? They issue a report, which at a court hearing, all the parties get together and they go over the GAL report, and they look at testimony to determine whether or not John Smith has capacity or not. And if it's determined that he does not have capacity, the court deems him incapacitated and then can appoint a conservator and a guardian to make those decisions for the person. Now, once you're a conservator or a guardian, you have to do reporting back to the court each and every year, basically an accounting of these are the dollars that the person had and these are how they were spent. These are the medical things that we've taken care of. And you do that until the person either passes away or they regain capacity. Now again, I'm glad that the system is there. It's a necessary system that we have to utilize when the times are right, but it takes a lot of money and it takes a lot of time to go through those guardianship and conservatorship hearings, and therefore we look to avoid those through the use of powers of attorney.
Great. So let's talk a little bit about the difference between the roles of a trustee versus a personal representative. I did have executor down here, but we're gonna change that. Can they be the same person? And also, what happens if a family member doesn't have any trusted person in their life that they feel that they can appoint for a role like that?
Yeah, really good question. So I want you to think of just different silos or different kingdoms that different people are in charge of. So if I'm wearing my personal representative hat, I am in charge of the estate of somebody who's passed away. Anything that's in their estate. I can be the same person, but if I'm a trustee, now I'm wearing a trustee hat, and I'm only responsible for the things that are in the trust silo or the trust kingdom. Now, I can be the same person wearing different hats. It's just what assets do I have authority over? So only those assets that were entitled into the trust fall into that trust kingdom. Everything else falls into the estate kingdom. People often will come to us and say, look, I don't really have anybody to manage these assets if I'm incapacitated or ultimately pass away. Fortunately, the courts can appoint, there are third-party trustees and personal representatives. There's some, I'm looking around at sponsors, there's a number of third-party firms that provide fiduciary services, third-party fiduciary services. They will serve as the personal representative. They will serve as the trustee. And all they're doing is they're following the rules of either the will, if they're serving as the personal representative, or the trust, if they're serving as trustee. They can't go and do whatever they want. They have to follow those rules. So people often get nervous, oh no, if somebody steps in, are they going to take over all the assets? No. They have the legal obligation to simply follow the rules of either the will or the trust. So rest assured, somebody will be appointed. Either you get to choose, or the court will appoint somebody if you don't have any documentation and you die. What's called intestate, just means without direction. The court will appoint a personal representative or a trustee.
Great. So what are the biggest pitfalls that you see on a regular basis when people have not taken the time to put these tools into place? And what are some personal stories that you might be able to share on that?
Oh, sure. The biggest pitfall is you can paint whatever picture you want. You can draft whatever documents you want ahead of time. But after something happens, our options are so much limited. There are so few options we have. So if you're a family and you've got young kids, or you're a family and you've got grown kids, and you want to draft an estate plan that says, I want child A to have this, and I want child B to have this, but child C is unfortunately, addicted to drugs, or has creditor issues, or has a special need that we need to hold their share in a special needs trust or something like that. We can make the documents dance however you want them to. But if you pass away and you don't have those documents in place, we are subject to whatever the statute in Michigan says, the intestate statute. So basically the state of Michigan gets to decide where your things go. And after somebody, even if they haven't passed away, after they've become incapacitated and they can no longer execute documents, we're kind of stuck, we're frozen. Just want you to think like a Polaroid is taken, okay, this is the plan we have after incapacity. Because the incapacitated person can't come back and change the plan. So often, it's no longer we're obviously not dealing with the deceased person or the incapacitated person, but we're dealing with the family who's left to fix the mess. One of the myths that I didn't really talk about was sometimes people have just said, I don't really care, I'm going to be dead. And, they say it a little bit tongue-in-cheek, and, it's a little bit of a joke, and I get it. But what they're really saying is, I don't really care what my family has to do. And so after somebody gets incapacitated, I'm dealing with the son, the daughter, the cousin, the whatever, who's now left to fix this mess. Often they're doing their best to try and fulfill whatever wishes the incapacitated person had. But I'll go ahead and say it's very selfish to just assume, okay, they're going to clean up my mess after I'm incapacitated. They're going to clean up my mess after I'm gone. So the biggest pitfall I want to avoid is fewer and fewer options after somebody becomes incapacitated. You can do anything you want with your estate plan while you're alive and have capacity. You can sing whatever song you want, but after you're incapacitated, just think that Polaroid is taken and your plan is frozen.
I have watched many a client literally have a breakdown going through this process of dealing with, estate homes and the stuff and the legal aspects. The family members that are left are already struggling with their grief, and then all of a sudden they're saddled with this absolutely huge to-do list, and depending on if someone's lived in a house for a long time, and they might have a house full of stuff that they haven't dealt with. I mean, we're not talking, a day or a couple days. We're talking whoever is dealing with this, they are often taking a break from their life, a forced leave of absence from work. They might have young kids. They can't parent the way they want to parent. They can't work the way they want to work because all of a sudden these things must be dealt with. And it's just incredibly challenging. I mean, I've been in that role before, and that was part of the catalyst for starting this series way back when, was I was put in that role. And honestly, it was very, very difficult.
Yeah, there's a lot of work that needs to happen when an estate plan is done perfectly. I'll never tell you that, oh, it's a breeze, it's super easy, and after you're gone, there's things that still need to happen. So we lost Dad about almost 2 years ago. And so my mom's in her late 70s now, and I do this for a living. And so I made sure that they had a great estate plan, and they do. But I do this for a living, and it's still a lot of work after the death of the first, let alone the death of the survivor. But it is exponentially more difficult and exponentially more work if there isn't any direction put in place and there isn't any legal authority put in place, and somebody becomes incapacitated or passes away.
Absolutely. So if anyone in our audience today really feels that their estate plan either might be out of date or they haven't done any kind of planning yet, what do you recommend as the very first step that they might do?
This is going to come as a big shock, but I'm going to recommend that you come talk to me or any other estate planner. So we offer free audits. You can bring in your existing estate plan and we'll tell you what it says and we'll say, does it need to be changed or not? And if you don't have any estate plan, we do free initial consults where you come in and we look at what are your goals for your estate plan? What do you have? And okay, these are the tools that we need to use to satisfy those goals. Michelle from our team is here. My cards are on the back. We'd be happy to meet with you. And like I said, it's free. And if you want to engage us, great. We offer a flat fee estate planning so you know exactly how much something costs before you ever sign on to anything. But whether it's with me or somebody else, please, please, please do talk to somebody because 100% of the people in this room are eventually going to pass away. And if we just address that elephant in the room, it makes it a little bit easier to deal with it.
And I would just top that off with most all of the reputable businesses that I deal with on a regular basis for estate planning, real estate, all these very, very important things. I don't know any of us that don't have and offer a free consultation. So if somebody's meeting with you in an estate plan and they're telling you it's going to cost money to simply meet and get some basic information, I'm going to tell you that's probably not the right person, because there are very professional and reputable options out there that will sit down, hear exactly what you've got going on in your personal situation, and at least give you a guide, give you that idea of a cost up front so that you can feel confident on moving forward.
Yeah, it's impossible for me to say I'm going to charge you something when I don't know that I'm the person that's actually going to give you value. And because each plan is custom, each person's needs are different. I can't tell you on the front end when something's going to cost. We have to meet to go find out, because someone might be worth $50 million and have an estate tax issue. Somebody might be worth $1 million, have no estate tax issue, but they might have a child with a special need. Somebody else might have an entirely different goal because they don't have any children and they want to give charitably. Well, all of those plans are very, very different. But if I don't know that I'm the one to provide that value, I don't feel right in charging people on the front end. That's why those consults, we're always going to make those free and allow you to come in, educate me on what your goals are, and I can educate you on the tools that we do to satisfy those goals.
Great. All right. Thanks, Jordan.